Hello, I'm Anthony Sicaro, founder and president of Providence Financial and Insurance Services, located in Woodland Hills, California. I'm also an attorney at law, an estate planning attorney in California, and host of the Providence Financial Retirement Show, which airs every Saturday on AM 870 KRLA's The Answer. And the purpose of this video, as usual, is to keep my clients informed. And if you're a client of ours, thank you for your business. Thank you for your trust. If you're not a client of ours, feel free to visit our website at providencefinancialinc.com and you can get more information about us. Now, let me tell you the purpose of this video up front. So if it's something you're interested in, you can keep watching. And if it's something that's not relevant to you, you can shut it off. The purpose of this video is I'm going to put on rather my legal hat, and we're going to talk about an issue surrounding living trust. And if you have a living trust that was drafted really 2012 or before, that has never been completely restated, then you want to have that trust reviewed. Now, if you're a client of ours, a review of your trust is complimentary. If you're not a client of ours, then there's going to be a fee, could be between $200 and $400, depending on the complexity of your trust. But that's the conclusion. So if you do not have a trust or you don't care about that or your trust is much newer than 2012, then you probably don't need to watch the rest of this video. But if you have an older trust, you want to pay attention. And the rest of this video, I'm going to talk about why it is that you want to have your trust reviewed. Now, the reality is that this gets to be a little bit complicated and it can almost be a little bit murky. So there are some things that you need to know in order for me to even have this conversation and try to impart this information to you. So the reason that you want to have your trust reviewed is because of the estate tax laws that were in place from 2010 and before that are significantly different now. Now you say, Anthony, I thought you said 2012 and before is when we want to have our trust reviewed. And you would be right. I said 2012. And the reason is because even though there were some estate tax law changes that really went into effect in 2010 and 11, well, some attorneys that drafted trusts in 2011, even though there were new rules, may not have caught up to the new rules yet. And if you had a trust drafted in 2012, maybe even 2013, then it may not be drafted according to the new rules because some attorneys just don't stay as current as others. I've seen that happen many times. So I think our general rule of thumb is if your trust was drafted 2012 or before, you want to have it reviewed. Let me talk about why. And in order to talk about why, we have to talk a little bit about estate taxes. An estate tax, like it sounds, is a tax on your estate when each spouse or when both spouse passes away. And the estate tax has been around for decades. And for decades, there's always been an exemption amount. So any amount above the exemption is what's taxed. Any amount of your estate below the exemption is not taxed. Now, let me give you a quick idea. Our current estate tax exemption is 11.7 million. That's for 2021. So if you pass away and you have an $11.7 million estate or less, then no harm, no foul, you don't pay any estate tax. Any amount over that is going to be subject to a 40% tax. So if you leave $1 million more than the 11.7 million, so you leave 12.7 million, then that $1 million is taxed at 40%. That's a $400,000 tax that your beneficiaries will have to pay upon your departure. Now, that's a very high estate tax today. Biden and company have talked about lowering it. There's really no doubt that at some point it's going to get lowered. Matter of fact, the Trump tax rules already have it in place that it's gonna automatically be lowered in 2026 back to, I believe it's five and a quarter. Actually, I think it's 5.5 million, but somewhere 5.5 million or thereabouts is what the new exemption is going to be. So we know it's going to go down. But with the new tax proposals that Biden is putting into place, it may go down to 2 or 3 million at some point well before then. We don't know. But if you go back to the year 2000, I'm going to refer to my notes here. If you go back to the year 2000, this exemption was only $675,000. So if you had an estate more than $675,000, then that amount, any amount above $675,000 would have been taxed not at 40%, but check this out, at 55%. 55%. So if you had $1,675,000, so there was 1 million more than 675 back in the year 2000, 20 years ago, well then that 1 million would be taxed at 55%. That's $550,000 of tax your beneficiaries would have had to pay. And they get 9 months to write the check to the IRS. So not a lot of time. In 2006, that exemption amount had jumped up to 2 million. By 2010, by 2009, it had jumped to 3.5 million. And then by 2010, it actually disappeared. So there was no estate tax. You could die with an unlimited amount of your estate and have no estate tax at all for your beneficiaries. You might remember the New York Yankee owners, George Steinbrenner. He died in 2010, and it's been estimated that he saved like $600 million in estate taxes, or his beneficiaries did, because there was no estate tax in 2010. And the reason is because the laws had been drafted up to 2009, so the estate tax increased exemption was already built in. But by the end of 2009, Congress hadn't done anything. These laws were set to expire in 2009. Congress didn't act. So when you get into 2010, there were no laws written about 2010. What do we do? So 2010 turned out to be we don't do anything. And that's what happened. They didn't do anything. So then in 2010, they drafted new laws, and the laws then went into effect in 2011 and beyond. Okay. So at some point, if you did a trust anytime in the last 20 years, that trust is gonna be drafted in some regards to the estate planning exemption. And let me explain why that is. Let's go back to the year 2006. Okay, and we'll use that 2006 number. The estate tax exemption in 2006 was $2 million. Now, keep in mind, this is your net estate. So any equity in your home, that counts towards the 2 million. All of your retirement accounts counts, all of your retirement accounts count toward that $2 million. Check this out. Any death benefits from life insurance count towards that $2 million. All your taxable accounts, all of that counts towards your $2 million. This is your net estate. So really, it's all of your assets minus all of your debt or mortgages. That's your net estate. If that amount is $2 million or under, then there's no estate tax. If that amount is more than $2 million, then the estate tax is going to be 46% for every dollar above $2 million. So if you left a $3 million estate, that $1 million would be taxed at 46%. That's $460,000 your beneficiaries would have the ability, would be forced to pay. Right? So 46%. Now, if you're single, then everything we talked about is true. But if you're married, there was something you could do to double your estate tax exemption. Right? And my goal is I don't want to give you all the inner workings and all the legal terminology behind the scenes. That would take us a long time to do, but I want to give you the big picture so you understand the method behind the madness. Okay? So back in, even current day, but back in 2006, if you were married and you drafted a trust specifically to help you avoid estate taxes, what that would do is that would effectively allow you to double the estate tax exemption just by drafting a trust. Now, we're going to talk about that trust in a minute and some of the drawbacks of doing that, but let's talk about the positive side. The positive side is that if the estate tax exemption was $2 million and you were married and you set up a trust, you automatically doubled your estate tax exemption to $4 million. Now, I say automatically, it's only automatic if the trust was drafted that way. Okay? So, but you double it to $4 million. So if you have a $4 million estate, okay, you die, you have $4 million. If you did not have a trust to give you that $4 million exemption, or if you're single and you weren't married and it wasn't even available to you, then that extra $2 million is going to be subject to that 46% tax back in 2006. So it would have been almost $900,000 of tax on $2 million. But if you had a trust drafted in accordance with law, then effectively that $2 million would double to be $4 million. So now if you died with $4 million, you save $900,000 of taxes because there would be no taxes due on either the first death or the second death by having this trust drafted properly to be able to save you from estate tax. Okay, so bottom line is you could double your estate tax exemption. That's the pro. That's why people would do it. Now, a lot of clients wanted it drafted this way, and a lot of attorneys drafted them this way without even telling their clients. But let's talk about what the negatives are. The positive, you got potential to save a bunch of money in estate tax, but there's some negatives. This type of trust, when it's drafted when both of you are alive, is going to be what's called an A-B trust. And your A-B trust is going to have assets in it. Okay, assets in it. So if you had a $4 million estate, then some of those assets are going to be inside the trust and some of them are going to be outside the trust, but the trust is certainly going to have assets in it. And when the first spouse passes away, that one trust that you have needs to be divided into two trusts, an A trust and a B trust. So it's called an A-B trust when you set it up, but it's really only one trust. But upon death of the first spouse, then it gets divided into an A trust and a B trust. The A trust is going to be the trust for the surviving spouse. That would be the trust for the person that is above ground. The B trust is going to be the trust for the decedent spouse. That's going to be for the person that is below ground. And what the trust does while you're alive, when it was drafted, is the trust has a formula that says this is how much needs to go into the B trust and this is how much needs to go into the A trust. And oftentimes, the most common way that these were drafted is that half of the amount that is in this trust, half of the amount would go to the B trust and half of the amount would go to the A trust. That's the way that most of these were commonly drafted. Now, why would we do that? Well, because anything that you shift to the B trust automatically comes out of the estate and automatically is not going to count for future estate tax purposes. So, for simplicity, and it gets more complicated than this, believe me, but for simplicity, if there was $4 million in that trust and we said the exemption is $2 million, then if that trust was divided in half, 2 million would go into the B trust, 2 million would go into the A trust. Whatever amount goes into the B trust is using the $2 million exemption for the spouse that deceased today. Okay, the spouse that is currently deceased, that $2 million exemption goes into the B trust. That's not going to count again for estate taxes. So that means that if there's $2 million in the A trust, when the surviving spouse passes away, that A trust, if it only has $2 million in it, is then also going to use the additional $2 million exemption. So together you use 2 million for the decedent spouse, the exemption, you've used 2 million for the survivor spouse, and together you've used $4 million of exemptions, which means no estate taxes at all. Okay. If you don't do this, okay, if you don't set it up with an A-B trust, then what's going to wind up happening is there is no B trust, there is no A trust. If you have a $4 million estate, there is a rule in the law which is called the unlimited marital spouse deduction, which basically says that when one spouse passes away, that spouse's estate for estate tax purposes is going to transfer to the surviving spouse. So now instead of being 2 million, 2 million, the surviving spouse has $4 million. And when that surviving spouse passes away, that entire $4 million is subject to estate tax. And if the estate tax is only $2 million, if the exemption is only $2 million, then the beneficiaries have to pay the tax on anything above the exemption. But by setting up this A-B trust, you can use the exemption of the first spouse when they pass away, but you have to transfer the funds to the B trust and transfer the remaining funds to the A trust for the surviving spouse. So essentially, you use the double exemption, but it has to be set up this way. So that's the positive, save a bunch of money in taxes. What's a negative? It's quite a few negatives. One negative is that this B trust is irrevocable. Once that first spouse passes away, if you have an A-B trust that is set up right now and the first spouse passes away, then this has to happen. You don't have a choice. Now, a lot of people don't do it, but you're opening yourself up to a lot of exposure. But this has to happen. If the trust says it has to happen, this is what has to happen. So you set up this B trust. So now when you set up this B trust, that B trust is irrevocable. What that means is that the surviving spouse can't change it. So whoever the beneficiaries are of this AB trust, whoever they are, that they are going to be the beneficiaries of the B trust, and the spouse cannot change that. The spouse is going to have their A trust, and the beneficiaries of this one trust before it gets divided is still going to be the beneficiaries of the A trust as well. But the surviving spouse can change anything they want about the A trust. They can amend it, they can redo it, they can disinherit, they can add on beneficiaries, they can do whatever they want. But they cannot do that for the B trust. The B trust is going to be locked in stone. Whoever the beneficiaries are of the single trust before it gets divided are going to be the beneficiaries of the B trust. So it's important, but that's a drawback because it takes control away from the spouse. Another drawback is that the spouse, the surviving spouse, does not have access to the principal of the B trust. So it gets divided, 2 million, 2 million in our example. Well, the surviving spouse does not have access to that $2 million in the B trust. They have access only to the income that that $2 million is going to produce. That's the way that most trusts are drafted. Every trust is different, so it depends on how your trust is drafted. But this is the most common, is that they're allowed to get the income, but they're not allowed to get the corpus or the principal. Right? With the A trust, they can do whatever they want. They can take that $2 million, they can spend it, they can do with it whatever they want. They're unrestricted with regard to the A trust, but they are restricted with the B trust. Now, most of the times, the trusts are drafted in a way to where if the spouse spends all their money in the A trust, then they can access the principal in the B trust. But so there's usually some exception in there like that. But until they spend all the money in A trust, the B trust is not even available. So it's potentially very restrictive for surviving spouses. And most of the times when I explain this to people, they go, no, we don't want that. We don't want to restrict our spouse. We don't want to make, they're already having a tough time. They're spouseless at this point, spouseless. And now just to put these restrictions and find out. And unfortunately, I've been involved in situations where people don't know this until it's too late. One spouse passes away, and then now they realize, well, that we got to divide the trust. What do you mean I don't have access to my money? So the reality is that's exactly what happens the way that it's drafted. Plus, because it's an irrevocable trust, it's got to get its own tax ID number, and it has to file taxes every year. And trust tax rates are very expensive. You get to the top trust tax rate, I think, at like $13,000. So the reality is it's just an extra expense. It's an extra headache. So what's happened in the past is if you have an old trust, a lot of attorneys, because of the significant doubling of the estate tax exemption, a lot of attorneys automatically set up these trusts as AB trusts. And almost every time when I review it with a client, they have no idea that this is the way it was even set up. So the bottom line is that if you have a trust that was set up anywhere before 2010, and theoretically, any attorney now could still be setting it up as an AB trust, although unless you have an estate approaching 11.7 million, it probably doesn't make sense at all. And the drafting rules have also changed a little bit to where now today, you don't need to set up this AB trust with all the restrictions. The trust that we draft today actually allow you to set up the trust so that if it becomes beneficial for you to set up an AB trust, then the surviving spouse can decide to do that. It's not mandatory. But for trusts that were drafted 10 years ago and beyond, most of the trusts made it mandatory that this is what had to happen. So if you had a trust drafted back in 2006 and you had $2 million in your estate, the attorneys might have said, well, hey, they're going to pay tax based on that law, based on the year that you did the trust. They knew that the tax rates were going to go up. They knew that you might have to pay a significant amount of estate tax. So what they might have done is just drafted it as an AB trust right out of the gate. And unfortunately, I find that none of this was even explained to people. And when I explain it, they're hearing it for the first time. So, and part of the reason why I'm even doing this video and I use the year 2006 is because that's exactly what happened. I was reviewing a trust in 2006 that the individual was saying nothing's changed. We'll just leave it. I go, let me just review it. Let me take a look. And I found exactly what I've just shared with you in that trust. And by the time I explained it to them, I said, look, you got to redo the whole thing. If you don't want this to happen, you got to redo the whole thing. And they were like, you're absolutely right. We got to redo it. Thank you for reviewing that trust. So bottom line is if you have a trust that was, again, I think 2012 or older, you want to have it reviewed. We want to make sure that if these provisions are there, you really want them there. If you don't want them there, we got to make sure to remove them. Again, if you're a financial client, financial planning client of our firm, there's no cost for you to review these trusts. We'll review it for you. If you are a financial client, if you are not a financial client of the firm, then there's going to be a charge. What we need to do is we can have a quick phone call. You can contact us. I can get an idea as far as your situation, and usually over the phone, just depending on how complex your situation is, I can let you know how much it would cost to review. Anywhere between $200 and $400 is usually the cost of the review. If you decide that you want us to make the changes for you that we recommend, then we'll subtract that amount from whatever the total price is. So it'll all be fair, all the way around. Or you go back to your own estate planning attorney. And same thing with my clients. A lot of my clients have used their own attorneys for years, maybe before they became clients. You don't have to use us. Go back to your estate planning attorney and make sure that you don't have this A-B provision in there. Have that conversation with them so it's at the forefront of their mind. So I hope this video has helped, and feel free to reach out to us again. Let us know if you want to have your trust reviewed. Someone from my office will call you and we'll coordinate that. Thank you. God bless.